Morning, Your Honor. May I proceed?
Please.
Morning, everyone. The matter before the court is Civil Action 2483 CV 00692. Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as C&F McCarthy's et al. Your Honor, for the plaintiffs, we have attorneys Daniel Buck and Mark Dillard present by way of Zoom. For the defendant C&F McCarthy's, we have attorneys Tamara Holstag and Lincoln Rose. For defendant Waterfall, we have attorney John Dealey and Asset, I believe. And for defendant Reed, we have attorney Sarah Shipley and Aaron Rosenberg.
Good afternoon, everyone. Good morning, excuse me. So, Attorney Dillard, do you want me to tell me your perspective of discovery at this point?
Sure, Your Honor. 25 depositions have occurred. There are still another 21 that are outstanding. A number of depositions had been noticed to occur that everybody was prepared to occur, and they were canceled at the 11th hour. I believe mostly by witnesses, but they're still on the docket to be occurring. There were several substantive depositions that are pretty significant to the parties in this case that ended up being canceled at the 11th hour that still need to happen, and I expect that from those depositions there will be follow-up questions that require further discovery.
When you say substantive depositions, tell me which depositions you're referring to.
Well, notably, Aidan Carney, Your Honor, failed to attend his deposition, which was scheduled on the 30th. We're preparing a motion to compel for sanctions. He then went on his live stream that evening and said that
I don't need to hear all the details. Just get your motion filed.
Yeah, so that hasn't happened yet. Miss Reed's suspended deposition has not finalized. It was supposed to have occurred, and for logistics reasons between all the parties, that was moved to another future date, so it hasn't occurred yet. There's also, I know that we're still have a 30B6 of one of the bars that is outstanding.
Is it scheduled?
Well, it was scheduled and it's come off the calendar, but is being rescheduled based on availability, and that's being discussed between the parties.
Okay. Do you want to offer anything else?
I'm sure I could offer a lot, but for now, that's probably a good stopping point.
Okay. Attorney Rosenberg.
Thank you, Your Honor. So from our perspective, we've taken 13 depositions. We have 3 more that are scheduled for dates certain before or including the 17th. We then have only 6 depositions that have yet to be scheduled because of witness issues. One of those obviously is Colin Albert, as you're aware. The others are just logistics with witness availability. Just to kind of get ahead of what I think we're going to be discussing, our proposal is that we're close, and we think we're going to get almost all the way there by the 17th. We would not object to parties doing some cleanup depositions, obviously, in the week or 2 that follow the 17th by agreement. And I doubt that anyone would object to that. We've spoken with the other defendants about that, and my understanding is they're okay with that. So I don't think we need an extension of your deadline. We've worked hard to get there, and I think we've gotten at least from my perspective, close enough. I'm sure you wish we'd gotten fully there, but I think we're very close. So I would ask we stick with the deadline, we set expert deadlines thereafter, and we continue to move the case forward.
Okay. On behalf of McCarthy's?
Good morning, Your Honor. I would agree that the parties have made a ton of progress. As has been discussed, over 24 depositions have occurred in a short period of time. There are several more to go. I count 17 left to go. Of those, only 3 of them are noticed depositions on behalf of CF McCarthy's, one of which is scheduled to take place on August 11th within the current timeline and tracking order deadline. The other 2 are 2 folks that were scheduled to go forward, and then there was a sudden family emergency, which we of course accommodated, and that just needs to be rescheduled with our counsel, and we're actively doing that. I also echo Mr. Rosenberg's comments and Mark's. The parties have been working and talking amongst each other about whether there needs to be any extension of the discovery deadline. We're fine if other people in the court are okay with us completing discovery that's already been pending shortly after the discovery deadline and trying to wrap everything up. I do note that some of that does seem to depend, though, on third parties, some of which haven't been as necessarily compliant, so I'm not sure how that is going to all track. I can't predict the future there. For CF McCarthy's, I also agree with Mr. Rosenberg that we need some firm deadlines after the close of discovery for staggered plaintiff's expert disclosures and also then defendant's expert disclosures, probably 45 days after the plaintiff's. And then we'd also request, Your Honor, that after all that has occurred, that the court set down a reasonable date for Rule 56 motions in the event that we need to bring such a motion to the court's attention.
Okay, on behalf of Waterfall?
Good morning, Your Honor. A lot of what I was going to say has already been said, Your Honor. On behalf of Waterfall, we have 3 more depositions scheduled for us to be principal people taking them. They're scheduled for today, for Monday, and for the following Monday. But obviously, we are participating and want to be involved and participate in the depositions that are still outstanding. So it seems pretty clear there's going to need to be some more time, and we're trying to work it out between us to get this stuff accomplished. We also agree with regard to McCarthy's indication that we would like to have or see the court amend the deadlines or add deadlines for expert disclosures, staggered disclosures, as well as push out the Rule 56 deadline beyond those expert disclosures so that we get the events in the right order so we can bring motions as necessary before the court, Your Honor.
Thank you. Did all parties propound interrogatories?
Yes.
Okay.
Yes, Your Honor.
Yes, Your
I
Honor.
assume there were expert interrogatories?
I actually don't believe there were expert interrogatories from the plaintiff. We, for Ms. Reed, certainly served expert interrogatories.
Okay, so if there are expert interrogatories propounded, presumably the answers would have identified some experts. Am I correct?
Well, I can respond as to the plaintiff's answer to ours. They objected that it was premature when it was served, and I believe indicated that they would amend that, but have not done so yet.
Okay. All right,
I know we have.
I didn't hear that, I'm sorry.
I was just going to say, Your Honor, we also propounded expert interrogatories, and I believe the response is similar to what Attorney Rosenberg just had said from the plaintiff.
Okay, well, I mean, the tracking order doesn't talk about expert disclosures. Tracking order talks about discovery, and discovery of experts, the identity, et cetera, is not only allowed, but it's required responses.
And Your Honor, if that from our perspective, from Ms. Reed's perspective, if you if your direction is that that supplementation to an already served interrogatory should happen by the close of discovery, that's fine with us.
For C.F. McCarthy's,
Okay.
Your Honor, I would say that decisions relative to experts on our part may go hand in hand with the defendants, but also need to go hand in hand with the completion of discovery. So I would say that we're more than happy to, of course, timely disclose and, expert interrogatories to all parties, and certainly intend to. But that is still in process for us.
Just to be clear, Your Honor, I said that because, as I said, the plaintiffs have not served an expert interrogatory on the defendants. So the defendants don't have an interrogatory answer to supplement. Only the plaintiffs do. And they have multiple ones.
We'll serve additional interrogatories.
Well, Your Honor, that it's too late to serve additional interrogatories in accordance with the current discovery deadline.
I believe that this current discovery deadline is the 17th of August.
Right, but that's not to serve discovery. That's for discovery to be completed.
I'll let you folks debate all that offline, okay?
Okay.
Anyone else want to offer anything else relative to discovery?
As it relates to discovery, Your Honor, we had requested and have reached out to the defendants to do an inspection of the vehicle with our experts. So as it relates to disclosure of experts, there are a lot of experts that will be disclosed ultimately in this case, though there is also a lot of data that's still being acquired through the discovery process that we are in need of before we can get to expert disclosures, though we are well aware of the need to do expert disclosures.
Your Honor, I would just reiterate on Ms. Reed's behalf that we've had a discovery deadline that was more than a year after the case was filed by the plaintiffs, more than a year after the stay of discovery of Ms. Reed. What has expired, and everyone's known there need to be experts, obviously. And so I think that work needed to have been done. If there's going to be a motion about this, I agree with you. I don't need to take your time to argue it right now. We can argue it if it comes to pass.
But Your Honor, may I respond briefly to that?
Sure.
The plaintiffs, though, when the criminal trial ended, we served discovery within 30 days upon the defendants. The plaintiffs did not obtain any of the documents, which were well over 1 million pages in digital and have continued to accrue since then, as you know, until sometime in or around January, and had difficulty accessing those documents. To suggest that we were able to procure experts and start working up the case before we had access to the very materials that the Reed team had access to since the criminal matters were going on. We didn't have that luxury. We were not the Commonwealth. Nobody would release to us all of that data while the criminal matter was pending, and then motion practice ensued, or there was discovery practice. And so this court is aware that initially there was a motion to dismiss filed that was heard and presided over last October. At that hearing, there was an announcement that we were going to be adding 10 new parties to this case, and that was to be briefed. That period of briefing occurred over the next 2 months, at which time, after the briefing, that was withdrawn. And it was plaintiff's position at that time that if there were going to add 10 new parties, it wasn't prudent for us to start engaging and and start pushing the parties to turn over the discovery if we're adding 10 new parties. Then when that came off the table, those other parties were added to separate lawsuits. we then started to receive discovery, but we had difficulty accessing that discovery. So I do appreciate the amount of time that this case has been pending, but to suggest that we were in the driver's seat since last July, that's not the case. We've been trying to catch up and get access to all the materials, and they were significant. In fact, I can also share with you, Your Honor, that the bars didn't have access to their own videos until we were able to get them through this discovery practice. And so there, in deference to the bars, it wasn't fair for us to force them into discovery when they didn't have access as well to all of the materials that had been outstanding because of the criminal case and were not being disclosed. So I do appreciate Attorney Rosenberg's position and understand that the Reed team feels as if they could be super diligent because they've had this case for 4 years. We've only had it in earnest since the end of 2025 into the beginning of 2026 with regard to access to all the data that needs to be digested and organize experts for.
Your Honor, Attorney Diller, I think, disagrees with me, but I still don't feel the need to go back and forth when there's no motion before you unless you want me to address anything.
I'm all set.
Okay.
Attorney Diller, when are you going to file the motion relative to the witness that didn't show up?
It'll be done today, Your Honor. In full transparency, that witness has disclosed that he is willing to show up, but I will tell you I would prefer to have an order of the court so that if it's skipped again, that there is something that puts him, forces him to actually go forward with the deposition. So
You say it's going to be prepared today, so it hasn't been sent out?
It hasn't been served 9A.
Do any of the other parties object to the motion?
Well, I don't know what the motion's going to say, Your Honor. I'm happy to.
The motion is probably going to seek compelling the witness to appear. Anyone object to that?
If that's the entirety of the motion, then no.
Your Honor, on behalf of
Let's say the
Waterfall,
mo-
we would not object.
On behalf of CF McCarthy's, we would not object either, Your Honor.
All right, so let's assume the motion also seeks sanctions. Are any of the other parties going to object to that?
I would say it depends what the sanctions are, there's a possibility we might not take a position on it. I can't really answer that without knowing what they're asking for.
Why would you possibly oppose a request to sanction a non-party that you have nothing to do with?
But I didn't say that I necessarily would, Your Honor. I said I don't know what the sanctions that they are seeking are. And so sanctions can obviously be a lot of things. And there may be an argument that the sanctions that are sought are not appropriate. I don't know. I'm in a vacuum. I can't tell you that, yes, I would agree to whatever sanctions they ask for.
Okay, so everyone agrees that a witness that didn't appear, it would be appropriate for an order to issue compelling that witness to appear. Is that correct?
Correct.
Attorney Diller, did you agree with that?
Yes, Your Honor.
Rosenberg, do you?
Yes.
Okay. You're having a little screen problem here, so I lost it. Here we go. Attorney Holstad, do you agree to that?
I do, Your Honor.
Attorney Dealey, do you agree to that?
Yes, Your Honor.
So how about I issue an order compelling the witness to appear? When do the parties want the witness to appear for deposition?
It's Mr. Diller's witness, so.
He's currently under subpoena for a rescheduled deposition to occur on the 17th. I will share with you that he has reached out and said that he's not available on the 17th, and has given other dates. The only dates that
I'll tell you what, Attorney Diller, you can file your motion to compel the witness to appear outside of 9A, given that all of the parties don't object to that.
Okay.
You can serve your motion for sanctions or whatever else you're looking for, under 9A, and we'll wait to hear Attorney Rosenberg's perspective on potential sanctions. So file your motion today
I will, Your
relative
Honor.
to compelling the witness. All
And
right?
as it relates to discovery, taking the deposition, if it has to occur outside of the discovery deadline, given our current situation, I just want to make sure that nobody's going to object to that.
From Ms. Reed's
But,
standpoint.
yeah, we don't need to do that here.
Okay.
I'll tell you, the court's never going to object to attorneys working together to get things done that are supposed to be done.
Okay, thank you, Your Honor.
Anything else? All right, thank you, everyone.
Thank
Have a
you.
good day.
Too. Bye.
Thank you, Your Honor.
Thank you, Your Honor.